On May 30th, former President Donald Trump was convicted of 34 felony counts of falsifying business records to conceal hush money payments during the 2016 election. That makes him the first U.S. president to be convicted of a crime. Hello, friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. In this episode, we'll explore the attitudes of presidents throughout U.S. history toward the judicial system and the rule of law, and what this history can teach us in the wake of the Trump criminal verdict. Joining me are two of America's leading historians of the presidency, and I'm so honored to convene them both. Stephen Knott is an emeritus professor of national security affairs at the United States Naval War College in Newport. He previously served as co-chair of the Presidential Oral History Program at the Miller Center of Public Affairs at the University of Virginia. He's the author of many superb books of presidential history, including The Lost Soul of the American Presidency, The Decline into Demagoguery and the Prospects for Renewal, and his most recent book, Coming to Terms with John F. Kennedy. Stephen, it is wonderful to welcome you to We the People.
Thank you so much, Jeff. It's always an honor to be with you and to speak to your audience.
David O. Stewart is a best-selling author and former trial and appellate lawyer. He is the author of many fiction and nonfiction works, including Impeached, the trial of President Andrew Johnson and the fight for Lincoln's legacy, and George Washington, the political rise of America's founding father. His most recent book, The Burning Land, is a novel set during the Civil War and its aftermath. In 2023, he received the Lifetime Achievement Award from the Washington Independent Review of Books. David, it is wonderful to welcome you back to We the People.
It's great to be here. Thank you.
The historical question we're exploring today is whether historically presidents have attacked the judicial system and what the effects of those attacks have been. Let's start with the aftermath of the contested election of 1800. Thomas Jefferson defeats John Adams and goes on to prosecute his vice president, Aaron Burr, for treason. David, you've written about the Burr trial. What does the prosecution and acquittal of Burr for treason teach us about whether or not President Jefferson attacked the system and John Marshall, who presided over the trial, as crooked or rigged, or whether the trial has a different lesson to teach us?
Well, I think that one sure lesson is that Burr was a better lawyer than Jefferson was. And Jefferson, I don't think, was actually attacking the legal system. He was manipulating it when he went after Burr. Burr was no longer vice president. He had, in fact, been engaged in a very suspicious-seeming activity in what was then the southwestern part of the nation. And as near as we can tell, he was hoping, all sorts of bad things would happen from Jefferson's point of view. It might even involve breaking off part of the United States into a new country. And he was arrested a couple of times and down in Mississippi Territory, and Burr kept getting freed by the local judges and the local juries. And then he was finally arrested, and Jefferson was fed up, and he had him hauled back to Virginia. Jefferson's fingerprints are all over this. He sent something like 20 memoranda to the prosecutors, led by a fellow named George Hay, who turned out to be James Monroe's son-in-law. And they prosecuted him in Virginia because they wanted to get the benefit of a Virginia jury. They figured they would dislike a New York City slicker like Burr, and they would side with Jefferson's viewpoint. And what happened was Jefferson missed the fact that there was no venue in Virginia for the illegal activities. They'd all happened outside of Virginia, which Chief Justice Marshall, who presided at the trial, pointed out in no uncertain terms. And Marshall made it clear to the jury that acquittal was correct, and they came back with an acquittal. Marshall's conduct was not perfect. He went to social events with Burr in Richmond during the trial, which is something that would be frowned upon in many sectors. But his conduct of the actual trial was not a problem. And Jefferson did not dwell on the verdict or get resentful about it. Burr's career was ruined. Jefferson had really tarnished, and Burr's own conduct had really tarnished his reputation. So Jefferson moved on.
That seems like a crucial point. Jefferson moved on. He did not support the impeachment of John Marshall, as Federalists had feared, and ultimately accepted the verdict. Stephen Knott, in your important chapter on Jefferson in your book on presidents and demagogues, you argue that Jefferson's attitude toward his opponents was borderline authoritarian, and he proposed treason trials for Virginia bankers who were brazen enough to cooperate with Hamilton's hated Bank of the United States. You talk about how Jefferson transformed the presidency from Hamilton's constitutionally constrained office into a popular one. And when you look at Jefferson's attitude toward the rule of law, beginning with his attacks on the Sedition Act convictions to his threatening of his opponents, would you call him a demagogue or not? And was he attacking the independence of the legal system at its core or not?
To give him the benefit of the doubt, Jeff, Jefferson believed in what today we would call coordinate review. He believed that all three branches of the federal government, legislative, judicial, executive, had an equal right to interpret the Constitution. So Jefferson, in a way, was an opponent of judicial finality, the idea that what the Supreme Court says is the law of the land and everyone must fall into line. So, much of his objection to the judicial branch was, I think, a philosophical one. I would argue, however, that he, and particularly some of his supporters, went beyond that sort of philosophical objection to the judiciary. And you see that in their efforts early in Jefferson's first term to impeach a couple of Federalist judges, a circuit court or appeals court judge named Pickering up in New Hampshire, and a Supreme Court Justice, Chase. They succeeded in impeaching Pickering. They failed in impeaching Chase. But that is indicative of a Jeffersonian hostility to a judicial branch that the Jeffersonians believed had gone well beyond what the framers had intended. And look, again, in fairness to Jefferson, the Alien and Sedition Acts and the judicial enforcement of those acts would give anyone pause, both then and now. And so certainly some Federalist judges had provided the ammunition that I think fed into the Jeffersonian desire to put the judiciary back in its place. And just one final quick point, Jeff. John Marshall, of course, was Jefferson's very distant cousin. The two men had disliked each other for quite some time. So I would also put into the mix here a kind of personal antagonism between Jefferson and Marshall. And the fact that John Adams had appointed John Marshall to be the Chief Justice of the United States in the final days of Adams's administration undoubtedly irritated the incoming president, Thomas Jefferson.
All such crucial points, both noting as you do the antagonism between Jefferson and Marshall, the fact that the Sedition Act gave ammunition for questioning the impartiality of those sedition verdicts, and the mixed verdict on impeachment, where the impeachment of Pickering succeeded and Chase failed on the principle that you shouldn't impeach justices based on disagreement with their opinions. I think that well sets up the mixed legacy of Jefferson and the judiciary. Well, let's turn to Andrew Jackson. He is the second of Stephen Knott's populist presidents who transformed the office from its roots in the founding era. During the Jacksonian era, efforts to nullify federal laws, like the hated Tariff of Abomination, led Calhoun and champions of the South to invoke the arguments that Jefferson had made in resisting the Alien and Sedition Acts and saying that states could defy uh, judicial orders that they disagreed with. David Stewart, when you think about Andrew Jackson's attitude toward the rule of law, including his famous, although perhaps apocryphal, comment in the wake of the Worcester and Georgia, the Native American decision, John Marshall has made his decision, now let him enforce it. How do you see Jackson in his attitude toward the courts and the rule of law?
If I remember correctly, Jackson actually was a lawyer, but a sort of a backwoods type lawyer, and didn't spend a lot of time at it. And I think he had a pretty rough and ready attitude towards it, and it was his attitude towards life. He did his best to mold the judiciary. He appointed one of his closest advisors, Roger Taney, to be Chief Justice. And what stands out in history about him and the Constitution is when he confronted the South Carolinians and said, the Constitution is the law of the land and it will be observed, or I will send troops into South Carolina. And that, for whatever his other views, it was the punch that really landed, and that I think makes him a significant figure in asserting constitutional supremacy.
A very important point that ultimately, confronted with these nullification-like arguments, Jackson chooses union and rejects secession and nullification by force. Stephen Knott, your chapter on Jackson is really powerful. You note that his vindictiveness was all-consuming, and when he was finally elected, a major prerequisite for individuals to be awarded a cabinet post was that he had to demonstrate a appropriate hatred level toward Clay. He introduces the spoil system and makes that a prerequisite for federal appointment. And yet, in the end, he didn't defy Supreme Court rules, and he and Marshall ultimately reconciled over their devotion to union. How much of a demagogue was Jackson when it came to attitudes toward the Supreme Court and the rule of law?
Yeah, I would say it's a mixed record, Jeff, and I share your and David's appreciation for Jackson's defense of the Constitution, for his defense of the Union, and for him staring down, in a sense, the secessionist movement that was starting to percolate in South Carolina. I would add, however, that there was, throughout his entire career, a kind of contempt for what today critics of the courts might call technicalities, a contempt for legalisms. And I'll give you one particular example. In the immediate aftermath of the War of 1812, when he had presided over the victory, the enormous victory at the Battle of New Orleans, Jackson imposed martial law on New Orleans in order to restore order. And while there may have been some strong arguments for doing that, he kept that martial law in place, most historians would argue, well beyond the point of necessity. And at one point, he actually had his soldiers march a judge out of town at gunpoint. And if that's not a kind of contempt for the rule of law, I don't know what is. That judge, by the way, had defended some dissidents, some newspaper editors who were critical of the martial law order in New Orleans. And again, Jackson had him marched out of town. To me, that's a fairly important point or event in Jackson's career that doesn't get enough attention. And then when you move towards his candidacy for the presidency and his assumption of the presidency, his description of his loss in 1824 as the result of a corrupt bargain, when there really was nothing corrupt about it. In my view, the system was working as intended, but Jackson was able to fire up his base by essentially saying that the deep state at that time had stolen the presidency from him. And again, in my view, it was a result of political bargaining between John Quincy Adams and Henry Clay to resolve a deadlocked election. And then you go into the presidency itself, and Jackson is all about the notion that the majority is to govern. And there is a kind of persistent contempt for the judiciary and for the notion that minorities have certain protected rights under the law. And so you see during the age of Jackson, efforts, particularly at the state and local level, by his supporters, not by him directly, to disenfranchise free blacks who had been given the right to vote, particularly in the Northeast. That's all part of this effort to implement this notion that the majority is to govern, and there's a kind of wholesale disregard for the rights of unpopular minorities, be they African Americans or Native Americans. And to me, that signals a kind of contempt for the rule of law.
David Stewart, we come now to the impeachment of Andrew Johnson. You've written a superb book about it, which teaches us that there were real fears that Jackson would displace the Reconstruction Congress by force, and there were troops marching on the city that looked like they might set up a coup, and Ulysses S. Grant had to decide how to respond. Again, a complicated story of the impeachment. You argued that it diffused the effort toward war and allowed the disputes to be solved peaceably. But how would you characterize Andrew Johnson's attitude toward the impeachment proceeding, toward the rule of law, and toward his opponents?
Andrew Johnson was an angry man, and he was a guy who never backed down from a fight. And the major political Donnybrook of his administration was between him and Congress, and not with the courts. And in terms of fighting with Congress, he was unrestrained, and he said crazy things. People thought they were crazy. You know, he compared himself to Christ and being crucified by these Judas-like characters in Congress. And he came across as a bit unhinged. The interesting thing is, for a man who had never spent a day in formal education, he was actually a pretty good lawyer, and he read the Constitution carefully. And when he ended up with this confrontation with Congress, which was over the Tenure of Office Act, which was a statute that limited his ability to remove an appointee that he disliked at that point. And it was Edwin Stanton, the Secretary of War, who was trying to undermine much of what Johnson was doing. And it was this hideous daisy chain of unconstitutional actions, basically, or actions contrary to norms. Congress enacted Reconstruction legislation. Johnson tried to undermine it by firing anybody in the South with the Army who was enforcing it, and then Stanton and Ulysses Grant began to disobey his orders, and both were acting contrary to what we would consider norms in what they did. They were doing it each, they thought, for a higher cause. In retrospect, we tend to think that it was Grant and Stanton who were really serving a higher cause by supporting Reconstruction and the rights of the freed slaves. But the Tenure of Office Act required that the Senate approve the removal of a high official. And the Senate was dominated by Johnson's opponents, and they would not approve the removal of Stanton. So he just fired him. And he wanted a confrontation. He was looking for a fight. And it proceeded in the Senate under an impeachment order. They'd already tried to impeach him once. And this was, all according to the rules. And he hired a bunch of good lawyers, and he fought it out on the theory that the Tenure of Office Act was unconstitutional. One of my real takeaways from the episode is that impeachment looks like a legal proceeding, but it isn't. it's a political proceeding. And, there were enough, by one vote, enough people who voted for his acquittal that he escaped being removed from office. And the Tenure of Office Act was ultimately, some 60 years later, declared unconstitutional in a decision that I actually think is wrong. But it was the Supreme Court's decision, so I don't really get to say that too much. So Johnson, long after his death, is slightly vindicated there. It is reminiscent of the Burr case to the extent that he really was ruined as a national figure by the episode, but he did not challenge or show disrespect, I think, for the court system. His disrespect for Congress was boundless. He really thought they were horrors, but he abided by the procedures that were set out. Now, I've just said that, and I need to qualify it. I found considerable evidence, which I believe, which persuaded me, doesn't persuade everyone, that he won because of bribery, that there were senators who were bribed, which was not uncommon in that era. And it was cash. It was nothing very subtle. But that's playing the game hard. Clarence Darrow played the game that way too. So there we are. It's not a pretty episode. I actually wish they had removed him just for our own redemption as a nation, but didn't happen.
Stephen Knott, David Stewart gives a thoughtful account of the Johnson impeachment as one ultimately based on a legal argument about the Tenure of Office Act, which the Supreme Court later struck down, and a president who did not attack the judges, although he did attack Congress, although complicated by the fact that it may have been bribery that made the difference. Do you see the Johnson impeachment as a vindication for the rule of law or not? And was Johnson's attitude toward the judicial system defensible or not?
Well, I certainly share the belief that the Tenure of Office Act had some very questionable it was of questionable constitutionality. My problem, my issue with the Andrew Johnson presidency was his efforts both to resist the Civil War amendments, the 13th, 14th, and 15th Amendments, all of which were designed to not just abolish slavery, but to try to protect the rights of 4+ million newly freed slaves. And Johnson did everything he could to resist those amendments. David alluded to the fact that he also undermined the efforts of the Freedmen's Bureau in the South that was sort of on the front lines of protecting the rights of these newly freed slaves. That's the problem, I think. So yes, no direct attacks, arguably, on the judiciary, but a wholesale effort to undermine constitutional amendments that he disagreed with. And that's problematic to me. The president takes an oath to take care that the laws be faithfully executed. Well, those amendments were now part of the fundamental law of the United States. And Andrew Johnson went to great lengths, as I've said, to undermine those amendments. And I would add to that, he, being a fellow Tennessean who deeply admired Andrew Jackson, there is this same streak of majoritarianism, or this notion that the majority should always govern. And that's what he's talking about when he's trying to undermine the Reconstruction governments in the South that are attempting to protect the rights of a minority. Johnson is all about getting the white majority back into positions of power. And he seemed to have, at best, an indifferent attitude towards the newly freed slaves. So again, in my view, that kind of unbridled majoritarianism is something of a threat to the rule of law if the law is intended to protect the rights of those groups who might be out of step with the majority.
Well said. Well, with that setup, I think we need a round on redemption, the subversion of Reconstruction, where after the withdrawal of federal troops from the South, mob violence, lynching, a reign of Ku Klux Klan terror was blessed by the courts, who struck down the enforcement acts that the Reconstruction Congress had passed and blessed the complete disenfranchisement of African Americans by the turn of the century. David Stewart, when you look at that story, which included the contested election of 1876, widespread allegations of fraud on both sides, and the bargain that led to the withdrawal of federal troops from the South in exchange for recognizes Hayes's victory. Lots of moving pieces here, but what is the lesson for the attitude of the presidents of the time toward the judiciary and the rule of law?
I would be inclined to stick with Stephen's construct of looking at majoritarianism. The United States was deeply racist through this era, and the presidents reflected it. The only president I can think of in this era who may well not have been a racist was James Garfield, and he got killed. And Ulysses Grant really wasn't. He did try to proceed with Reconstruction, but for the others, it wasn't worth the fight to try to resist what was going on. The contested election of 1876 between Tilden and Hayes, I felt rather stupid the other day when talking to someone who's working on it, and I realized, well, wait a second. I've always thought ill of Hayes for having rolled back Reconstruction and his own corrupt bargain, if you will. But the fact is, if Tilden had won, he would have killed Reconstruction too, because he represented the Democratic Party, which was their power base was in the South. So that was going to happen, and that persisted and persisted, and it was in both parties. And the courts rolled over because they had the same attitudes. The only, there are a few voices in the slaughterhouse cases and civil rights cases, and in Plessy versus Ferguson, there are judges who say this is not right. The constitutional provisions do, as Stephen said, guarantee or purport to guarantee these rights, but the Supreme Court was no majority was willing to enforce them, and it's a deeply dispiriting era to study. For years we ignored it because there was no war, or historians ignored it because there was no war, there was no triumph, and now I think people are digging into it a bit more. But I will speak for myself. It's a depressing era. It's hard to spend a lot of time with these people. They're doing rotten things. So it makes it difficult. People don't want to buy books about them. So it causes an under examination, which I think persists.
It really is a depressing and indeed shocking era. And just to read cases like the Supreme Court's Cruikshank case, where Joseph Bradley, sitting on circuit, allows a mass murder and terror and strikes down the Enforcement Act on a complete Jeffersonian technicality that he rejected in cases involving legal tender, and just completely subverts the 15th and 14th Amendments is indeed shocking. Stephen Knott, how do you see the redemption period? Does your construct was this majoritarianism thwarting the Reconstruction Amendments? What was the role of judges, and what does it teach us about our current vexations?
I think it was, Jeff, majoritarianism run amok. But added to that was this desire on the part of many Northern Republicans who had, of course, supported the Civil War and probably had backed the Civil War amendments. They put reunification over protecting the rights of this unpopular minority group. People they just grew tired of it. And that's a common phenomenon in human affairs. You get tired of an issue, so let's just move on and pretend everything is okay. So it's reunification over the rule of law. And you have a number of, including some Republican presidents, who make appointments to the Supreme Court. And these appointees are in that sort of reunification camp. And again, to me, it's another major downside to this majoritarianism belief or principle, if you will, that has very deep roots in America. And I completely understand the notion of the right of self-government, the people to govern themselves. I'm not opposed to that. But we are also about the rule of law. And this was a real test case. This post-Civil War period was a real test case about whether the rights of an unpopular minority were going to be protected as the law required. Never mind morality, but as the law required. And unfortunately, we failed that test in this post-Civil War era. I would just say, both David and Jeff, you're absolutely right. This is an incredibly depressing period to study, but there are some positive role models who emerged during this period. This is a relatively unknown figure, but Amos Ackerman was Ulysses S. Grant's attorney general for a period of time. He is a former Confederate soldier. And he, during the period from 1870 to 1871, as the Attorney General of the United States, basically destroys the Ku Klux Klan for a time in various parts of the South. If your audience is looking for a positive example of someone who believed in the rule of law, who believed in the intention of the 13th, 14th, and 15th Amendments, take a look at Amos Ackerman and the transition that this man experienced, going from a Confederate soldier to an enforcer of civil rights and a destroyer of the Klan, is truly remarkable.
Wonderful. Thank you for the recommendation for Amos Ackerman. And in terms of heroes on the Supreme Court, David alluded to him, but of course we have to give a shout out to the great John Marshall Harlan, who, in the spirit of the great chief for whom he was named, was the only justice in Plessy and the civil rights cases to actually enforce the Reconstruction amendments. Well, this brings us to the progressive era. Let's think about the election of 1912, pitting two populist presidents who insist that the president is a tribune of the people against a traditional Hamiltonian, my hero, William Howard Taft, who's insisting that the president's job is to resist the perturbations of the public mind. We have attacks on judges from all sides, including Theodore Roosevelt, who's attacking individual Supreme Court justices by name for their rulings, calling for judicial recall, and saying that Supreme Court decisions should be able to be overturned by popular vote. The Democratic platform also endorses direct primaries and initiatives, and there's plenty of judge bashing on that side too. David Stewart, when you look at the progressive era attacks on judges by candidates such as Theodore Roosevelt in particular, but also Woodrow Wilson, is this a departure from the 19th century norm or not? And to what degree was it a threat to the rule of law?
Well, certainly calling out individual justices was not the norm before. And, I think it's important to look at the whole culture, the political society, which was really in significant ways being turned inside out by the progressive movement. Direct election of senators, approval of the income tax. There were some major changes that were being adopted. And, the idea really was that the people, and this is through the use of direct amendments to state constitutions and plebiscites on public issues, that it was about really strengthening the majoritarian rule, and that, uh, you know, at the end of the day, any government, and certainly one that purports to be a republic or even a democracy, public opinion ends up controlling. We can shake our fingers and say tisk tisk, but that's the deal. And that was happening. And, Woodrow Wilson, who does some wonderful things, also, happens to have grown up in Georgia. And he really had all the attitudes of a Georgian of the 1870s, which were a deep racism, much more than some of his predecessors who simply had sort of were going along with whatever the dominant view was. So he brings some hideous qualities as well as some excellent ones. It's an era where Roosevelt has been using the courts in his antitrust campaign in a creative way, and and I don't mean to make him into a cartoon figure, but not unlike many presidents, he's all for the courts when they do what he wants, and then he's angry when they don't. And then I wish that was different with someone, but I'm not sure I could come up with a list. So that is a continuation of the pattern, and again, it's an era I would suggest when the courts are not at the center of American life. I think when we get into World War I and the resistors and the pacifists who were prosecuted, that's another pretty dark period, and the courts just go along, and that's another unfortunate era period. And that is the Wilson administration. Times of war, times of crisis are generally bad for individual rights, and they were.
A crucial point that Wilson's racism during his administration, which included the imposition of Jim Crow segregation on the federal government, led to the reign of terror of the Espionage and Sedition Acts after the war and the prosecution of his political opponent, including Eugene Debs, who would run against him in 1912 and had to run for president in 1920 from a jail cell because Wilson prosecuted him and the Supreme Court upheld the conviction. Stephen Knott, you've written so powerfully on how transformative the Wilson presidency was in creating the potentials for a modern demagogue. To what degree did Wilson's populism and insistence that the president directly channeled popular will lead to subversions of the rule of law and attacks on the judicial system?
I think there was, unfortunately, among many progressives of that era, a kind of contempt for the Constitution and the framers. Now, look, to some extent, I think they were correct that the framers had achieved almost, the status of sainthood, that they were never to be questioned. That's not particularly healthy in a republic. But there was another part of that message that was also contemptuous of the notion of limited government and very much in favor of what we've been talking about here, this notion that the majority is to govern. And importantly, that the president is the spokesman for the majority. Both TR, in his stewardship theory of the presidency, spoke about the president being in a position to basically do whatever he pleased unless there was specific constitutional prohibitions or some congressional act that prohibited him from acting. And Wilson embraces this stewardship theory and is flat out quoted as saying, the president of the United States needs to be as big a man as he wants to be. And to me, again, that is underlying that there is a kind of contempt for the notion of limited government, for respect for the other branches of government, including the judiciary. And you really see this come into full flower under Franklin Roosevelt, who openly expresses contempt. I don't want to get ahead of ourselves here, for the Supreme Court, for particular judges. I think in some instances he may have even named them. So you see this evolution. TR opening the door to a stewardship theory that has a kind of conception of unbounded presidential power. Wilson embracing it and seeing the president's role as sort of listening to public opinion, but also shaping it and serving as a spokesman for the majority. And then FDR kicking the door wide open and sort of blatantly criticizing the court for objecting to any of his New Deal provisions. So to me, though, that's a kind of troublesome development. Interestingly enough, at the state and local level, there were some, for lack of a better term, progressive courts. Judge Louis Brandeis will refer to the states and localities as laboratories of democracy, because in many instances, states were well ahead of the federal government in terms of protections for workers, minimum wage laws, child labor laws, etc. So as you mentioned, Jeff, this is a very big issue. There was a kind of diversity of opinion amongst some progressive toward the courts. But on the whole, I would say when we're talking TR, Wilson, and FDR, there is this underlying contempt for the Constitution and for particular Supreme Court justices.
Thank you very much for that. Thanks for introducing the crucial question of FDR and his legacy, as you teed up. His contempt for individual judges and attacking them by name, of course, led to his attempt to pack the court and his introduction of the court packing plan, which was rejected by Democrats in Congress as a threat to the American constitutional tradition, but is part of, you suggest, FDR's general contempt for the judiciary, and the court packing plan is a dramatic example of that. Because I do want to get to the present, this is a wonderful way of helping us put the current trial in context. I think we're going to leap over FDR now to Richard Nixon, because we've got to talk about Nixon and Clinton, and then we'll have something to say about the Trump conviction. David Stewart, what does the Nixon Watergate experience and impeachment teach us? Was it the system working, as Gerald Ford said when he took the oath of office after Nixon resigned? Or was Nixon's attempts to use the law to prosecute his opponents, his attacks on judges, and his a part of a more general attack on the rule of law?
The Nixon administration, and we've had I think, overdue reconsideration of it in the last 20 years or so. And I would recommend specifically Jack Farrell's biography of Nixon, which is a terrific reminder that although he was the Prince of Darkness to my generation, he actually did some awfully good things. And the fact is, he tore up the Constitution in his actions towards opponents. And he tore up norms, and he behaved unforgivably. And the one thing that is redeeming for me about Nixon, and I don't, the thing that I keep referring to whether a president was a good lawyer or not, but Nixon was a very good lawyer. When I was in my first year of law school, I actually read his law school note for the Duke Law Review, which is not at all political, and it's really quite smart. And the fact was, it felt, and maybe it's not true, he was full of resentment, always. Like he sort of came to his senses at the end. Now, maybe it was driven by the fact that he'd been told he was going to lose the case. And a group of Republican legislators go to the White House and say, Mr. President, you're going to be removed, which was a sobering message, to be sure. But I think that was, it triggered something in him and made him reconsider where he was and face the music. And he resigned. Would the impeachment process have torn the nation apart? Would he have ultimately somehow skinned out of it? We'll never know, which I think is just fine. And there was a backlash. There was an attempt to introduce more ethical norms and to have some restrictions on the presidency through legislation. It empowered Congress for a period. And, it wasn't a long period, which is sort of a shame. And, Congress has proved to be increasingly unwieldy and less effective through my lifetime. But, the Nixon story is a tragic one. And we lost a good deal as a country, but his resignation was a good moment, and one really forced by events and by the actions of other branches of government. The Supreme Court stood firm on his subpoena on the tapes. Congress and the Senate, with its Watergate hearings, delved into what was going on and revealed it. So it was in some ways a revival of the other branches of government who acted responsibly and in many instances acted without regard to party affiliation. So it's an episode that we can, oddly take a little pride in.
The system worked, the other branches did their job, and it's an episode we can take some pride in. Stephen Knott, any additional thoughts on the Nixon impeachment, including, is it significant that although he tried to go after his opponents and had enemies list and so forth, he did not attack the impeachment process itself? But then I'd like you to put on the table the Clinton impeachment. And in that case, Bill Clinton and his defenders did attack the women who accused him. They tried to discredit Paula Jones, Monica Lewinsky, and many others. Did Clinton also attack the impeachment process and the rule of law or not? And what can we learn from the Clinton impeachment?
I share many of David's views regarding Nixon. I was certainly no fan at the time, and I thought he did significant damage to the notion of the rule of law. On the other hand, as David pointed out, he did ultimately resign. Now, a key development there, as David mentioned, is that members of his own party urged him to step down and warned him that he was likely to be convicted and removed in the Senate. And that's something we don't see these days when it comes to presidents getting into trouble. So that was significant. But looking back, Nixon's actions in comparison, as you said, Jeff, to Bill Clinton, seem altogether statesmanlike. The Clinton administration decided at a certain point that they were going to run a campaign. They basically recreated their war room, as they called it, from their 92 campaign against H.W. Bush. And they campaigned against Kenneth Starr, the independent counsel who led the investigation. And Starr was by no means perfect in that job, don't get me wrong. They campaigned against the House Impeachment Committee. They campaigned, as you mentioned, Jeff, against the individual women. Paula Jones was described by one of Clinton's top aides as somebody who'd drag a bunch of dollar bills through a trailer park to get her attention. I mean, really low, disparaging attacks against witnesses, both before impeachment committees, the impeachment committee, and before a grand jury. And then, of course, President Clinton himself, as Special Prosecutor Robert Ray concluded, was misleading at best in terms of his testimony, both in the civil lawsuit brought by Paula Jones and in the Lewinsky matter under Kenneth Starr. The president he takes an oath to take care that the laws be faithfully executed. That's important. And if you have a president who has contempt for that, I think you're in a heap of trouble in a republic. And I think Bill Clinton, unfortunately, did undermine a kind of healthy notion of the rule of law with some of his rhetoric that painted this as entirely partisan, when in fact the president was less than truthful in various legal settings.
Thank you so much for that. Well, with this superb discussion, we're now very well equipped to arrive at the present. And when he was convicted, President Trump said, "This was a disgrace. This was a rigged trial by a conflicted judge who was corrupt." He also attacked the jury, the prosecutor, and the entire state judicial system as under the control of the Biden administration. And he called on his supporters to overturn the conviction at the ballot box. He said the real verdict is going to be November 5th by the people. David Stewart, now that we've had a thoughtful exploration of historic attitudes toward the judicial system, the jury, judges, and prosecutors, would you say that President Trump's statement was historically unusual or not? And does it have historic precedent or not?
I can't think of a precedent, and I think his statements have been unforgivable. It, emboldens people who get convicted to just say, "Oh, it's all rigged." And he's going to take an oath to support the Constitution if he wins. And how could we think he will? He does nothing. I mean, nothing in that trial, the way it was conducted, was in any way disturbing to someone who practices law. Now, the charges were a bit adventurous, and that will be tested by the appellate courts. Adventurous charges sometimes work. That's how the law advances. And whether it was smart to do that in a case against the former president is something I think we need a little perspective on before we get to. But Trump's statements are, in fact, utter demagoguery. They are totally irresponsible. And it really is disturbing assertions that I've heard from somebody in that position. We need to have leaders who actually support the system. We've and the anti-hero is the popular figure in all of our movies now and has been for 50 years. But the president is not an anti-hero. The president is somebody who's supposed to pull us together and maybe improve the system. But he or she stands at the top of the system. And to have someone utterly contemptuous of it is profoundly disturbing.
Thank you for that. Stephen Knott, do you think that President Trump's statement that the trial was rigged and his attacks on the judge, the jury, the prosecutor, and the entire state and federal judicial system are historically unusual or not? And what might the consequences of the statements be?
Well, I share many of David's concerns about former President Trump's statements. I think they are, for the most part, unusual. I mean, again, Franklin Roosevelt did attack judges who were ruling against his New Deal initiatives. Richard Nixon campaigned in 1968 in a way against the Warren Court for its permissive rulings on law and order. So presidents have criticized the court as courts in terms of their rulings on constitutional matters, on matters of individual rights. But this is different. This, as David mentioned, I see as an attack on the jury system, which is at the very base, the very foundation of Western liberal democracies. And if you start to undermine the jury system and you're a candidate for the presidency, I find that remarkably disturbing. We've already had one norm shattered, the norm of peaceful transitions of presidential power. And now I see a kind of frontal assault on the jury system that is incredibly troubling, again, for anyone who's a believer in Western-style liberal democracy. So I do see these most recent attacks of President Trump as qualitatively different from those of an FDR or a Richard Nixon or Jefferson or a Jackson, who've expressed displeasure over the court's rulings on constitutional or separation of powers issues. Attacking the jury system is a new level of presidential rhetoric, one that we've never seen before and one that's incredibly troubling.
Many thanks for that. Well, it's time for closing thoughts in this extremely illuminating discussion. David Stewart, the first one is to you. Polls in the wake of the Trump acquittal showed that not just President Trump, but many of his supporters, including those in Congress, are sharing his attacks on the jury system and the judicial system and saying that it is rigged. Democrats are countering that the system should be allowed to take its course. What are the consequences for America if large numbers of Americans come to believe that the jury system is rigged and embrace political attacks on the courts and the rule of law? And are we at a sea change in our willingness to accept the nonpartisan authority of the rule of law?
I wish I had a snappy answer to that. I quite frankly don't know. I think we're as close to walking away from our basic principles as we've been certainly in a long time, maybe since the Civil War. And I can't make up my mind whether these people who are answering polling questions are just unthinking, if they just think Trump's a good show, he puts on a good performance, or if they really do accept and endorse what he's saying. It would be a terrible wrong turn for us if the latter is true. I think we need to turn away from this. And perversely, because I never like agreeing with Mr. Trump, I think he's probably right that November 5th is the day that matters, and we need to. We're going to learn a lot, and we learned a lot on election day 2016, and I'll freely admit I was shocked, and I won't be shocked this time, but I'll be greatly alarmed if he is returned to office. And let me just say, Stephen's point about the peaceful transfer of power is just equally disturbing. Those are two norm-shattering moments. This stuff about the court system and then that opposing the peaceful transfer of power. We can't have either of those and still proceed.
Thank you very much for that. Stephen Knott, last word in this important discussion is to you, to the degree that many Americans are embracing President Trump's attacks on the jury system and questioning the nonpartisan legitimacy of the rule of law. Is this a sea change in American history or not? And what might its consequences be?
Well, again, at the risk of sounding like I'm ducking your question, I agree with David. In a way, we will find out soon. And I hate to, I'm not trying to make this partisan in the least bit. I want to make it clear to your listeners, I've actually written books in the past. I've defended George W. Bush and some of his conduct in the war on terror. I'm not somebody who's people who know me would classify as a liberal activist of any sort. But I am deeply concerned, along with David. We will find out this fall. Now, there is an event coming up that should occur prior to November 5th, and that's the trial of Hunter Biden. If Hunter Biden is convicted by a jury of his peers, and if the White House issues a statement saying that they are abiding by the rule of law, that will be a very important development. If the White House comes out swinging and says some of the same stuff that Trump and his supporters said last week or a week or two, then we'll know that the battle is lost. But as long as there is a president willing to say, even when a family member, a beloved son, is convicted by a jury of his peers, if that president is willing to say, this is how our system is intended to work, We respect the verdict. I'm going to continue to love my son, whatever, but the verdict must be respected. That's going to be an important development should Hunter Biden be convicted. So we'll see about that as well.
Thank you so much, David Stewart and Stephen Knott, for a thoughtful, wide-ranging, and illuminating discussion. It is so important in these challenging times to deeply learn from history, and both of you have done so much to help cast historic light on these remarkable circumstances. David Stewart, Stephen Knott, thank you so much for joining.
Thank you, Jeff.
Thanks a lot.
Today's episode was produced by Lana Ulrich, Samson Mastashari, and Bill Pollack. It was engineered by Bill Pollack. Research was provided by Samson Mastashari, Cooper Smith, and Yara Derese. Please recommend the show to friends, colleagues, or anyone anywhere who's eager for a weekly dose of historical illumination and constitutional debate. Sign up for the newsletter at constitutioncenter.org/connect. And always remember that the National Constitution Center is a private nonprofit. Despite that inspiring congressional mandate, we receive essentially no government funds, and we rely on the generosity of people from across the country who are inspired by our nonpartisan mission of constitutional illumination, education, no obfuscation, and lots of celebration of our history and the important issues that it raises. So support the mission and learn about history by becoming a member at constitutioncenter.org/membership, or give a donation of any amount to support the work, including this podcast, at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.